Good morning friends. In this series of Aibe preparation for the exam on 5th February 2023, we have been discussing the previous question papers of the Aibe. I hope this will be helpful to those who are appearing for the exam. We have discussed Constitution, CPC, CRPC and IPC. Today we will be discussing the question paper of Evidence Act. So let us start with the question number 1. How many kinds of presumptions are there as classified by the Supreme Court? Friends, this would cover the section 4 of Indian Evidence Act, in which it says may presume, shall presume, conclusive proofs. Here our answers are permissive presumptions or presumptions of facts, compelling presumptions or presumptions of law, that is rebuttal presumptions, and irrebuttable presumptions of law or conclusive presumptions. The answer is all of them. Under which section of the Evidence Act admissions are defined? Admissions are defined under section 17 of Indian Evidence Act. In fact, section 17 to 13 are covered for various type of admissions, which includes the confessions also. But the different admissions are defined under the section 17. In which of the following cases the Supreme Court has held that the investigation officer should be allowed to refer to the records of the investigation? That is the state of Karnataka versus Yarappa Reddy. Indian Evidence Act came into the force on 1st September 1872. Promissory estoppel against the government agencies is defined in the case of Purnima All Mills versus State of Kerala. Purnami All Mills versus State of Kerala, where the promissory estoppel against the government was referred. Admission can be broadly categorized into the judicial, extrajudicial, either A or B, both A or B. Answer is both judicial and extrajudicial. Section 66 of Indian Evidence Act lays down a notice must be received under the section 65A of Indian Evidence Act. Notice to produce a document must be in writing. Order 11 Rule 15 of CPC prescribes the kind of the notice to be produced as a document. All of them are answered. Here section 61 to section 100 Indian Evidence Act have details with respect to various documents. So section 66 talks about these things. When the accused states, I will produce the share which I have received in such and such robbery, which of the following are not admissible with regards to the section 25, that is with respect to the confession to the police officer not to be proved. That is, in admission there was a robbery, admission that accused took part, admission that he got a part of the property, and a statement as to where the property is. The answers are 1, 2 and 3. A statement where the property is not required. A intentionally and falsely leads B to believe that certain land belongs to A, and thereby induces B to buy and pay for it. The land afterwards becomes the property of A, and A seeks to set aside the sale on the ground that at the time of the sale he had no title. He will not be allowed to prove his want of title. Which section of the Evidence Act applicable? Section 115 of the Evidence Act is applicable for, this is a estoppel, change in the statements. So section 115 is for the estoppel. In fact, estoppel is covered under the section 115, 116 and 117. Why I am referring to the sections? Because we are allowed to take the bare acts where we can also refer. We will have enough time for reference. Next question, the question is whether A owes B rupees 10,000. Which of the following statements are relevant to the Indian Evidence Act? Options are: facts that A asked to C to lend him money. D said to C that in a presence of A and hearing, I advise you not to trust A, for he owes B 10,000 rupees. A went away without making any answer. All of the above is the answer. So much of such information, whether it amounts to a confession or not, it relates to the distinctly to the fact thereby discovered by the police, may be provided under the section 27 of the Evidence Act. Section 27 speaks how much information received from the accused may be proved. When the court has to form an opinion upon a point of foreign law of or a science or a art, or as identify handwriting or a finger impression, the opinions upon the point of the persons especially skilled in such a foreign law, science or art are in question as to identify of handwriting or a finger impression are relevant facts. This is covered under the section 45. Section 45 is the opinion of experts. Please remember, section 45 is the opinions of the experts. Res gestae, relevancy of the facts forming a same transaction is dealt. Res gestae is dealt under the section 6. That is, in fact, section 5 to section 31. Section 5 to section 16 talks about the relevancy of the facts, and section 6 directly talks about the relevancy of facts forming a part of the same transaction. So here the section 6 of the Evidence Act is the right answer. A is accused of waging a war against the government of India by taking part in an armed insurrection in which the property is destroyed, troops are attacked, and the goals are broken up. The occurrence of these facts is relevant as forming a part of the general transaction, so A may not have been present at all of them. Under which section Indian Evidence Act this is referred? Again, this is the same transaction, so section 6. Section 110 of the Evidence Act deals with burden of the proof to ownership. Burden of the proof to ownership is under section 110. Friends, section 101 to 114A talks about the burden of proof. The moment you get any question on burden of proof, you may refer to the sections 101 to 114A. Section 113A of the Evidence Act deals with presumption as to abetment of a suicide by a married woman. This is also a question, part of a burden of proof, where the section 113A talks about the presumption as to abetment of a suicide by a married man. When a married man commits a suicide within the 7 years, it is presumed that it is due to the abetment of the suicide. It also amounts to the murder also in some of the cases. So one of the following statement is not true. Which one is that? And whenever you have these questions, you have to refer to the acts too, because all of above or none of the above, if the answers are there, better always refer to relevant sections. In this case, a confession by the person in the custody of a police officer to any person in the presence of a magistrate can be proved. One of the following is not true. Already we discussed the confession in presence of a police cannot be taken into the consideration as per the section 25. of the Evidence Act. Kashmira Singh versus State of MP is a leading case of the confession of the co-accused. Confession of the co-accused is also taken into consideration, that confession of the other party. Which of the following facts is not relevant in civil or criminal cases under Section 8 of the Evidence Act? Section 8 of the Evidence Act talks about the motive, preparation and previous or subsequent conduct. So, in this, attempt is the one which covers under the criminal law, but it is not relevant in the Evidence Act. Under the Evidence Act, the character of a person is not relevant in which of the following cases? It is again the same thing. The previous good character of an accused, previous bad character in reply to a good character, character to prove the conduct of the imputed civil case, character of the affected amount of damage is civil case. So, character to prove the conduct in imputed in civil case is the right answer. Which one of the following is primary evidence? Documents produced for the inspection of the court is the primary evidence. If it is proved that a man has not been heard for 7 years by those who would naturally have the heard of him if he were alive, the presumption under the Section 108. Section 108, we also talked about the burden of proof, 101 to 114A. So, under 108, if a person is not seen for more than 7 years, he is considered as is not alive. So, here the answer B is 7 years. A dumb witness gives his evidence in writing in the open court. Such evidence would be called as an oral witness. Although he is a dumb, he is giving in writing, so it is an oral witness. Which of the following is not a public document? So we have to refer to the documentation. What is a public document? What is not a public document? Bank books, postmortem report, judgment of the High Court, registration of the sale deed. Here the registration of sale deed is a private document, whereas the bank books, postmortem report, judgment are the public documents. Under Section 118 of the Indian Evidence Act, this is with respect to the witnesses. 118 Act says, if witness is a major, not lunatic and not extreme old age, or is capable of understanding the question put to him or giving the rational answers irrespective of the age. Yes, irrespective of the age, if he is a rational in understanding and putting forward his views, is the right answer. Which of the following judgment is irrelevant under Section 43 of Indian Evidence Act? Section 43 of the Indian Evidence Act talks about the judgments other than those who mentioned in the Section 40 to 42. So it is a judgment of the criminal court. It's not relevant. Under which section of the Indian Evidence Act a witness has been given the right to refresh his memory? Section 159, which is under the examination of the witnesses, which are from Section 135 to 166. Under 159 section of evidence, refreshing memory is given the opportunity or a right to the witness. The next question, a dumb witness can give his witness to writing, which is considered as the oral evidence. Under which section of the Indian Act, which of the following is not a court? Persons legally authorized, judges, magistrates, arbitrations. Arbitration is a alternate judicial process. It is not considered as a court. Section 89 of CPC gives the ADR related reference. A question suggesting the answer with which the person putting in wishes or expects to receive is called leading questions. A leading question is the one the examiner leads the witness to answer. That is a leading question. A communication made to the spouse during the marriage under Section 122 of the Evidence Act. Section 122 of the Evidence Act related to the communication during the marriage, and it is considered and remained privileged even after the dissolution of the marriage. Even they are not remaining as a wife and husband, whatever the communication made, which becomes a privileged communication. Which section of the Indian Evidence Act provides that an accomplice is a competent witness? Section 133 talks about the accomplice, and accomplice can be a witness for the court. Who is prevented from being testified under Section 118 of the Indian Evidence Act? Section 118, a lunatic who cannot understand the questions, extreme old person who cannot give the rational answer, a tender age person who cannot give the rational answer, all of the above. All these witnesses have to be testified under Section 118. As we discussed earlier, if he is having a reasonable understanding and can give the evidence, it can be accepted. Any confessional statement by the accused given to the magistrate is admissible. Confession statement to the magistrate is admissible, while confession statement in the police station is not admissible. These are covered under the section 17 to section 31, and the confession talks about the section 24 to section 30. Kashmira Singh versus State of the Punjab is a leading case. This we have to see. This is neither a dying declaration nor an admission nor a confession. In civil cases, Indian Evidence Act bestows the burden of the proof on petitioner. See, in criminal case, it is the state who has to take the burden of proof. In case of civil cases, Indian Evidence Act bestows the burden of proof on petitioner. Dying declaration must be made by the dying person in hospital, doctor who is treating, or deceased before death, or nearest relative. Dying declaration should be by the person before he is dead. Any question suggesting the answer which the person putting it expects to receive is called coercive, confusing, misleading, rhetoric. Suggesting is kind of a coercive question. Indian Evidence Act is enacted in 1872, 1st September. Proving the handwriting is provided in the Indian Evidence Act under the opinion of experts and the evidence of a person who is acquainted with the handwriting. Section 26 of the Indian Evidence Act. This is again with respect to the confession. No confession made by a person in a police custody is admissible, which is right. Confession made by a person in a police custody is admissible, this is not right. Confession made in the immediate presence of a magistrate, it is admissible. So answer is A and C. The term evidence means it includes oral, documentary, electronic record, all of them. All of them is the right answer. Under section 59 and 60, which deals with the oral evidence under the chapter 4. Under the section 59 to 60 Indian Evidence Act, the oral statement means all the statements made before the witness, before the court by the witness, all the statement made before the police by the accused, all the statement of the facts which witnesses had to say, all of them more. All the statements which are given before the magistrate or a court is the right answer. Under Evidence Act, the court includes all the judges, all the magistrations, not all arbitrators. Admissibility of the contents of the electronic record may be proved in accordance with the section 65B of the Evidence Act. Electronic record 65A and 16B deals So under section 65B of the Indian Evidence Act, electronic records may be proved in accordance with this particular provision, which is not a public record as per the provisions of the Indian Evidence Act. This question already got repeated. Documents forming acts of the records of sovereign authority, which is a public. Documents forming acts of the records of the official bodies or a tribunal, this is a public. Documents and correspondence of the advocacy and notary office, they are private, they are not documents, they are not public. Under section 18 of the Evidence Act, the admission of which of the following is not admissible against the other? One of the defendants' admission is not accepted as admissible. Which of the following statement is correct? A confession made by the accused with the police officer is relevant. Confession made by accused in the police custody. Confession made by accused in the police custody. Discovery made from the information received by the confession. None of them above are correct. Anything related to the confession with the police is not admissible. What is the maximum number of witnesses which can be produced in the case? There is no limit of witnesses. Any number can be produced. Which section of the Indian Evidence Act is based on the English doctrine res gestae? Res gestae is covered under the section 6 of the Indian Evidence Act. Friends, this is a part of first part of the Indian Evidence Act, and we'll deal with more previous questions in the second session. Until then, please review this. You can listen to that and have a good memory. So after that, we'll be going to the some more questions of the previous exam of Indian Evidence Act. Hope this will be useful to you. Please like, share and subscribe to the channel. Thank you.